Guys, we are going to jump right into it. We have a state supplemental brief that seems like it was written by Fani Willis herself in response to the closing arguments that most of us agreed had low energy from the state side. And then we're going to get into the response from one of the co-defendants, Clark, his attorney, Harry MacDougald, who was called Mic Drop MacDougald on closing arguments because of the way he walked away from the podium, has already issued a response. He is the first to make a response, but others are apparently coming. That's the one we're going to look at for today. If you missed closing arguments on Friday, some key things to know and how we got here and why I think Fani went in and wrote this herself, or at least had a good part in writing it, is as soon as we had some pushback from the judge, the state did lose steam.
Appearance of conflict is dicta. Why do you think that's dicta? I think the quote from that one is, it guarantees at least the appearance of a conflict.
So he pushes back on some case law, and right here we watch the state lose steam. Just look at him.
I don't disagree with Your Honor, but in that case, an actual conflict was found, and the appearance.
They didn't find that.
I would disagree with Your Honor. My reading of the case is that an actual conflict was found, but because of that actual conflict, an appearance of impropriety was seen, and that's the reference, or why the state referenced that case in relation to the argument that an actual conflict is required.
The phase.
In the series of cases, Young, that was referenced by defense counsel, as well as Nichols.
So he goes through it. He ends up getting some more pushback from the judge, and then from that point forward, you know, looking at the chat comments as this was going on live, people were noting like, oh, he seems nervous. He seems like nerves are getting to him. To the point where all of a sudden, Fani Willis comes up and puts a post-it on the podium, and by the time he's done giving his closing argument, the way Fani walks out of this room, I feel like she went right to write this supplemental brief that she ends up filing on March 5th. So watch how she walks out here. She is on a mission. She is going to go save this closing argument. She's going to go resuscitate it. And just to show you who MacDougald was, if you watch the closing arguments, Harry MacDougald was this guy.
Disqualified and the case should be dismissed.
So he filed a reply to the brief we're going to read first from Fani. So let's get into that. Again, this is going to be the brief filed first, the supplement filed first after closing arguments. So, state supplemental brief following hearing on March 1st, 2024, concerning standard of proof and legal standard for disqualification of an elected district attorney. Now, while we go through this, I want you to decide, if you did watch the closing arguments, if you think this is a better presentation than what we got with the PowerPoint and the delivery on Friday. At the hearing on March 1st, concerning defendant's motion to disqualify District Attorney Fani T. Willis, the court posed several questions to the parties concerning the standard of proof required for disqualification and the legal standard to be applied by the court. The binding case law in Georgia is clear. A trial court is not authorized to disqualify an elected district attorney absent a showing by, quote, a high standard of proof that such an elected district attorney either has an actual conflict of interest or has engaged in forensic misconduct, and we have a footnote already. This brief will not examine the legal standards surrounding forensic misconduct, which was covered extensively at the hearing. So they're not even going to tackle that here. They're going to leave it as to what was delivered in the PowerPoint presentation. The state maintains that the evidence presented does not even come close to establishing that the district attorney's statements, quote, were part of a calculated plan, evincing a design to prejudice the defendants in the minds of potential jurors, the standard requiring for a finding of forensic misconduct. And they cite Williams v. State here. No prosecutor in Georgia has ever been disqualified from prosecuting any case on grounds of forensic misconduct, and this case should not be the first. This brief will address the standard of proof recently recognized by the Georgia Court of Appeals and the few circumstances. So they're going to keep emphasizing through this that when there is disqualification, no matter what party it's involving or the reason for, you know, the legal reason, what's the standard that this disqualification is happening, it's few. It's very conservative. They do not like to take this type of action to disqualify someone. And I'm sure we're going to see that, little reminders of that sprinkled throughout this, that this is barely ever done, and it shouldn't be done now. So recognized under Georgia law that constitute actual conflicts of interest for prosecutors. As a threshold matter, quote, the elected district attorney is not merely any prosecuting attorney. She, so they had to change the language. You know, it's always written like he by default, so they make it a she here for Fani, is a constitutional officer, and there is only one such officer in each judicial circuit. So they cite McLaughlin versus Payne. Under Georgia's constitution, a district attorney is constitutionally mandated, so they're italicizing that to show that it's a must. It's not a maybe. To represent the state in all criminal cases in the Superior Court of such district attorney circuit. Here the district attorney seeks only to do exactly that, perform her solemn duties as mandated by the Georgia Constitution to subserve public justice. In a case of great public importance. I think we can all agree. I think both sides can agree that this is a case of great public importance. The defendants asked the court to impose a novel hair trigger standard for the disqualification of an elected district attorney, but no such standard exists under our law. The true legal standard, set forth by our appellate courts and confirmed by statutory language, is much higher and requires proof of an actual, palpable conflict of interest, with a substantial basis in fact. So Lamb v. State is cited here. We'll probably see this cited a bunch more times. That standard is high for a reason. The public's interest in seeking justice is in no way served by a low standard that would allow trial courts broad authority to invalidate the public's choice in their elected district attorney selected by the people to carry out essential constitutional duties. And our state Supreme Court reinforced this high standard just weeks ago. So they're putting that date right there, just so we know. February 6, 2024 is when they're pulling this. All criminal defendants have certain rights that must be protected by our system of justice, but among them is neither the right to be tried by a prosecutor of his choosing, nor the right to delay his prosecution for no good reason. Inappropriate or improper disqualification of a district attorney elected by the people of the county and constitutionally mandated to represent the state in all criminal cases in the Superior Court of the circuit has severe consequences, both for the people's faith in their constitutional right to be represented by a district attorney elected by them. See, generally, they cite Kemp v. Gonzalez. That was recent, too. And for the public's confidence in our system of justice. For the reasons set forth below, so we're going to get into all the arguments now. The defendant's motion to dismiss the indictment and disqualify the Fulton County District Attorney's Office should be denied. So argument 1 is going to be that the defendants bear the burden of proof for the disqualification. So they need to prove their claims by a high standard of proof, which necessarily must be more than a preponderance of the evidence. Quote, it is the burden of the party seeking to disqualify counsel to prove that the extraordinary remedy of disqualification is warranted. And then we get a bunch of citations here. In McGlynn v. State, the Georgia Court of Appeals recognized that a court considering a defendant's motion to disqualify an elected district attorney and her office based on alleged misconduct must, quote, and must isn't part of the quote, but the quote says, hold those who allege such misconduct to a high standard of proof, and they add the emphasis there. At the hearing in this case, the defendants urged the court to adopt a preponderance of the evidence standard, but under McGlynn, that cannot be the correct standard of proof. Now, this line right here is exactly why I think McDougald is the first to respond. Because when McDougald started his closing argument, he got up there and he said, Judge, I am going to only talk about actual conflict of interest, and I'm going to assume that standard of proof. So it's no wonder why he's the first of the co-defendants' attorneys to step up and respond to this motion. While not squarely addressing in the context of disqualification, Georgia's appellate courts have often categorized a, quote, clear and convincing showing of actual malice as a, quote, high standard of proof. Moreover, the 11th Circuit Court of Appeals, remember that's if you go out to the federal level, the 11th Circuit includes Georgia, I think Alabama, and Florida. So, moreover, the 11th Circuit Court of Appeals has regularly and explicitly recognized that preponderance of the evidence is not a high standard of proof. And then they cite a ton of cases. The state maintains that the defendant has not established an actual conflict of interest, even by a preponderance of the evidence. But even so, based on these cases, specifically the holding in McGlynn, that trial courts must hold defendants seeking disqualification of a prosecutor to the high standard, the court should hold the defendants to something higher than a preponderance of the evidence standard. So, we're done with argument 1. Argument 2, the defendants ask the court to adopt a legal standard that's not recognized under Georgia law, and they rely on cases that are either cited in a misleading way, are inapplicable, or actually support the state's position. Now, if you watch the closing arguments, this is where we're probably going to see some of those cases that were in that PowerPoint, and maybe it was some of the ones that the judge gave pushback on. Let's see. The defendants rely on numerous cases in support of their motion that are either cited in a misleading way, are inapplicable, or support the state's position. The defendants can point to no appellate case, because there is no case, where an elected district attorney in Georgia was properly disqualified solely based on the appearance of a conflict of interest or other appearances of impropriety. Indeed, if such a case existed, it would undoubtedly have been brought to the court's attention by the defendants months ago. Instead, the defendants cobbled together flowery, righteous quotations from inapplicable cases that may sound enticing at first, but that entirely misstate the law in Georgia. In doing so, the defendants asked the court to adopt a novel legal standard for the disqualification of an elected constitutional officer that has never before been recognized in Georgia and is contrary to decades of case law. The cases relied on by the defendants can be divided into 5 categories. 1. Cases that don't deal with disqualification at all, but that the defendants use as a source of flowery and righteous, though inapplicable language. So completely irrelevant, they're saying. 2. Cases where criminal defense attorneys were disqualified on the basis of divided loyalty in violation of Georgia rules of professional conduct. So basically there's a codified reason that these people were disqualified. There's no ambiguity. Cases where a prosecutor had an actual personal interest or stake in the outcome of the prosecution. And 4, a single case where a defendant was denied a fundamentally fair trial where the district attorney had previously represented the victim in the case. And 5, cases where no actual conflict of interest was shown and disqualification was not proper. The first category of cases is the largest. We have a footnote, but the last sentence here says, the court should categorically disregard them in the context of this motion, as they say nothing at all about the disqualification of an elected district attorney. We're going to get to the footnote, but I really think they missed the chance here, and they should have taken it. I don't think there's any risk to them to have taken it here, but I really think they should have gotten ahead of the obvious next thing that Judge McAfee would say reading this, because he's said it out loud in court. Well, this is a unique circumstance. How often do you have a situation with a district attorney and a special prosecutor where any party is alleging some type of, misconduct, whatever the actual situation underlying that is? How often do you have someone, it's a top level position, so there's a smaller pool of people that have ever been in that seat, let alone had someone come forth and say, hey, there's an issue here. So really, I don't see why in this brief here, the state could have gotten ahead of that. They could have said, hey, we understand that there's cases that are few and far in between, but these things are really a stretch for them to try to sift through and cherry pick and try to say they're applicable or parallel to this type of thing. They're not going to be persuasive. So there's no actual case law related to the situation, and even the ones they're saying are kind of persuasive, they're really not similar. They shouldn't just ignore the elephant in the room and try to make it a problem that there's no existing case law, as if that's a dirty trick the defense is playing. The judge has already stated specifically, we know this is a rare circumstance. I think they should have addressed that in this paragraph instead of making it look like it was something more extreme. And then I just want to say, hey, and yeah, so hey, Daddy K. So yesterday I tried to look into this supplemental brief just to see where they mentioned the Whitworth case. But now we're going to look at it in full, and I'm doing it kind of early because I have a lot I have to get done today. But shout out to Barbara O. You guys probably saw her in the chat yesterday. She was the one that pulled this filing up initially, and she's also the one that grabbed the response that we're getting from McDougald. And then he goes. And then, so if they lose, it's because of him. Are you referring to, the PowerPoint presentation on closing arguments? And yeah, you're saying that it must be. This is much better. If they had a strong closing argument, the judge would not have questioned him. And, sometimes I think the judge, he really seems interested in case law and appellate law. I don't think it's necessarily a bad thing if he's asking a question. He might be interested in thinking about things in a new way. But the problem is he didn't get a response that kind of pushed a new way of thinking about things. The response was a lot of silence and nerve-wracking. And I don't blame the guy. That's kind of like human, but that kind of sucks when you're up there, that's your job, your boss is sitting behind you. And yeah, that post-it note probably said you're fired. I gotta go write this myself. So we're getting some expansion here. We have a subsection A here on this argument too. So cases involving criminal defense attorneys disqualified on the basis of divided loyalty are not applicable here. Oh, did I miss the footnote? Okay, so the footnote just gives a bunch of the cases that they're going to talk about here, including these do not concern disqualification at all. So cases involving criminal defense attorneys disqualified on the basis of divided loyalty are not applicable here. The second category of cases, so first was addressed by the footnote, we're going to get to number 2. So the second category of cases concerns criminal defense attorneys who were disqualified on the basis of divided loyalty in violation of the Georgia Rules of Professional Conduct, specifically relating to representation of individual clients. These cases simply do not apply to the disqualification of a constitutional officer whose loyalty lies with seeking justice, not with any individual private client. Beginning with Registe versus State, maybe that's like, I'm butchering that. The Georgia Supreme Court upheld the disqualification of a criminal defense attorney who had previously been directly involved in the defendant's prosecution, including filing an application for search warrants against the defendant. The court held that the circumstances implicated at least 4 ethics rules. And Rule 1.7 specifically prohibits the attorney's representation of Registe, whatever his name is, because the representation created a significant risk that the lawyer's duties to a former client will materially and adversely affect the representation of his present client. This is a lot of ellipses. How long was this writing in the decision? And because the representation includes the assertion of a claim by one client against another client in the same proceeding. The conflict cannot be waived. Moreover, Rule 1.9 also prohibited the representation. A lawyer who has formerly represented a client in a matter cannot thereafter represent another person in the same or a substantially related matter if that person's interests are materially adverse to the interests of the former client. These rules simply do not apply to the circumstances alleged in the defendant's motions. And we get a footnote. So in the context of cases implicating Rule 1.7, courts have considered whether the facts create an actual or serious potential conflict of interest, because when Rule 1.7 applies, the rule requires that consideration. Rule 1.7 establishes that a conflict of interest exists in representing a client if there is a substantial risk that a lawyer's own interests or duties to another client, a former client, or a third person will materially and adversely affect the representation of the client. So in the present case, where Rule 1.7 is not implicated, a serious potential conflict of interest is insufficient to disqualify an elected district attorney. Okay, so they're saying a serious potential conflict of interest is insufficient to disqualify because they're not specifically bringing up Rule 1.7. I think that's what that footnote is saying, but maybe I'm reading that wrong. Oh, I don't know. The remaining cases in the second category follow the same logic. In Edwards v. State, a criminal defense attorney was properly disqualified where he had previously represented the mother of the victim in the case, and neither Edwards nor the victim's mother gave informed consent to the conflict created by the defense attorney's divided loyalties, as required in Rule 1.7. In both Brown v. State and Love v. State, defense attorneys were disqualified where members of their firms had previously been employed as prosecutors and were substantially involved in earlier stages of the defendant's prosecutions. So I say down here, the Georgia Rules of Professional Conduct, in their current form, became effective January 1st, 2001. Love was decided under a prior version of the rules, and Brown was tried in April 2001 and relied on cases decided under the prior rules. Accordingly, neither Love nor Brown explicitly references Rule 1.7 of the current Georgia Rules of Professional Conduct. So finally, in Reeves v. State, a defendant's conviction was reversed, so now we're dealing with post-conviction. His criminal defense attorney had accepted a job offer with the same district attorney's office that was prosecuting the defendant. The record did not establish that the defense attorney had disclosed that fact to the defendant. And 3, the defendant asserted on appeal that disclosure of his attorney's future employment would have affected his decision-making. And 4, the defense attorney waived a jury trial, called no defense witnesses, and failed to have the bench trial transcribed. While Reeves refers to an appearance of impropriety, it is factually distinct from the present motion, was decided under the former ethics rule that do not apply here, and is non-binding physical precedent. And now we're going to get to a different subsection. So the third category of cases involving prosecutors with a personal interest in the outcome of a proceeding demonstrate that no disqualifying conflict of interest exists here. The third category of cases relied on by the defendants consist of cases where a prosecutor had acquired a personal interest in the outcome of the proceeding. So this is where we heard a lot about this in closing arguments, this Greater Georgia Amusements versus State, and Amusement Sales, Inc. versus State. Special prosecutors were disqualified from civil asset forfeiture proceedings where they were paid on a contingency fee basis. While Greater Georgia Amusements refers to the appearance of a conflict of interest necessarily created by such a contingency fee arrangement, the case was ultimately decided on public policy grounds, not conflict of interest grounds. So that references dicta. And the judge we watched, that's the clip I played at the beginning of this video, the first pushback they get with that presentation, the judge is like, why do you think that references dicta? I don't think it's dicta. So we'll see. I think this is really that moment. And I won't play the full clip because it's like 3 minutes here.
There's a personal interest in the case due to...
But this is him trying to explain it.
Situation and where at one point they were opposing parties. And of course there's a personal interest or stake as it relates to prosecuting an opposing party in a civil claim, which are what both of those cases reference, which shows that there's an actual conflict of interest that relates to the personal gain of the specific prosecuting agency.
And what do you make of Nichols' reference to?
So there was some back and forth pushback on that conversation. And again, the initial question from the judge was, I don't think that's dicta. Why do you think it's dicta? So I really don't think Fani Willis thought the presentation was, is that John Floyd? I really need to learn names and faces. It's hard for me when they're not like built into the screen. But he didn't really, I don't think he got through his argument of why the judge should consider that to be, yes, it is dicta. And Fani Willis, I really think she bolted out of that room and she pulled this up and she started writing and she's doing it herself. Because we're going to see here, she's the first signatory on this motion, on this brief. So they quote here that it is dicta because the application of a legal standard that the court merely assumed and explicitly did not adopt. And we have this footnote that the same can be said for the Georgia Supreme Court's reference to the appearance of impropriety in Battle v. State. In that case, the district attorney was not disqualified because there was, quote, no evidence, ... of any conflict of interest or a personal relationship with the victim or his mother or any personal interest in obtaining the sought. Is that incomplete? Are we missing? Did the footnote like go sought convictions? Okay, so the footnote carries on down here. Where the court did not adopt an appearance of impropriety standard in rendering its decision, that language is necessarily dicta. The court in Battle applied an actual conflict of interest standard, and again, no Georgia prosecutor has ever been disqualified based solely on the appearance of impropriety. Because again, this is true. Like there's small sample size, but you know that doesn't stop someone from asking something to be the first instance of something. So I think they should stop trying to act like this is because there's been so many times people have tried to do it, and every time we say no. That's not really the issue. The issue is there just hasn't been an opportunity. There's been no circumstance that brought a DA and a special prosecutor where someone's issuing a motion to disqualify in this way. So rather than present it as this so many times and it's always hammered down as a no, it's just something that's novel. It's a new legal question. And I think it would have been smart for them not to kind of dance around that. So yeah, that footnote was cut off weird. Now we're going to this page. And dicta is not binding on anyone for any purpose. Moreover, Greater Georgia Amusements is non-binding physical precedent, and fewer than 6 weeks after it was decided, the binding, better reasoned opinion in Amusement Sales, Inc. held that such contingency fee arrangements created an actual conflict of interest in light of the special prosecutors having a personal financial stake in the outcome. So they're saying this would only apply if the personal interest is related to the outcome, which we heard not just in the closing arguments, but we also kind of heard it repeated by Senator Harold Jones in asking questions for the minority party at the Senate hearing yesterday. Focus on convictions being the outcome, having a personal interest in the conviction, excluding anything that may lead up to that outcome. So now we're seeing that italicized here, which is why if you heard me mention, I really think Harold Jones had read this before he went into the Senate hearing. Amusement Sales, Inc. Oh, and they're citing it there. In the remaining cases in this category, disqualification was appropriate based on actual conflicts of interest. In Young v. Rel Vuitton, I wonder what that case was. Special prosecutors in a criminal contempt action were disqualified because they also represented the plaintiff in the underlying civil injunction action that gave rise to the criminal contempt action, and their prosecution of the criminal case gave them a bargaining chip in civil negotiations. By the same logic, in Nichols v. State, the Solicitor General was disqualified from prosecuting Nichols for perjury in an underlying civil personal injury action where the Solicitor General, in his private capacity, also represented the personal injury plaintiff against Nichols and allegedly used the criminal prosecution to force a settlement in the personal injury case. As this court correctly pointed out at the hearing in this matter, and as these cases demonstrate, to create a disqualifying conflict of interest, a prosecutor's alleged, quote, personal benefit must be material. There must be some factual relationship between the alleged benefit and the prosecutor's involvement in the case in order to show a personal stake or interest in the outcome of the proceedings. So they cite Amusement Sales, Inc. again. Here, the defendants have not even alleged, and certainly have not proven, that the district attorney received any benefit. So again, look at what's italicized. This is the focus on a point in time, contingent upon the outcome of this case. So again, the case really we haven't had kickoff yet, right? We haven't even gotten to the actual beginning of the Trump RICO case with the jury sat to start hearing that case. We're not there. We're like in the locker room right now. So obviously everything that's being alleged right now isn't really contingent on the outcome of the case unless you technically look at things like plea deals, which in legal terms are a conviction, right? That is kind of an outcome. So we do kind of have four convictions, so 4 outcomes for 4 different individuals. But there's still obviously an open case going on that really hasn't started. So they're going to keep emphasizing this because we're obviously not at the finish line. So we can't say that the outcome was an issue. There's no need for any type of post-conviction relief because we haven't gotten there yet, Judge. So obviously this doesn't apply. That's the argument that's being made. A nebulous alleged benefit that is either 1, not personal, or 2, not directly tied to the outcome of the case, traditionally the conviction of the defendant, is not, and they're saying traditionally there, not always. The conviction of the defendant is not enough to warrant disqualification. So they cite Sutherland, disqualification not appropriate, where the, quote, criminal charges have no factual connection whatsoever to the alleged personal interest, and the outcome in neither proceeding would in any way have an effect upon the other. So, in other words, would it materially have impacted the outcome of the case? Again, this is the post-conviction realm, and we're not really, in my opinion, we're not in a post-conviction period of time with the Trump RICO case. It hasn't even kicked off. But at the same time, I guess you could say, well, there's such a small sample size of case law available. We've got to look at what's there and see what can apply, right? This is such a novel legal question for Judge McAfee to have to deal with. So otherwise, as this court observed at the hearing, any alleged improper personal benefit received by a district attorney under any circumstance would disqualify her from prosecuting every case in which she signed her name to the indictment. That is obviously an unworkable interpretation of the law. And then let me see. And then shout out for the love goes. Yeah, if you guys hit the likes, that would be awesome. Mostly I love just doing this so we have the chat here. Yesterday, the chat was so live, I had a hard time keeping up with it while also listening to what was going on, so that was really cool. And then Jimmy says, it's not like Fani was dating someone on the defense team. They will do anything to save Trump. Well, and that's kind of like the issue I keep repeating, right? Is like, they're saying it's not relevant because they're not dating someone that's an adverse party. But at the same time, then you're dealing with such a small sample size of case law where there really isn't adverse case law. There isn't adverse precedent. There isn't adverse authority that says, hey, we actually think it's fine if someone's dating, but it's this position, like say the DA and the special prosecutor. on the flip side, there just isn't case law that says that is okay. There's nothing that affirms that either. So as a legal question, there has to be some type of adjudication there. And that's unfortunately, that's on Judge McAfee's plate, and I would not want to be him because it's a big case. I mean, it's like nationally televised. You can see how many people are looking at it. I would not want to be that guy answering that legal question. And I think he's like up for election too. I mean, I don't really know, anything Fulton County related with elections because I'm in Florida. But I imagine that's kind of like, he's kind of in a damned if you do, damned if you don't, I think. And I think he just wants to find the letter of the law to follow, something that says, if this is this, you just do this. So we're going to get to subsection C here. So the remaining cases relied on by the defendants demonstrate that no disqualifying conflict of interest exists here. The fourth category of cases relied on by the defendants, a single case, Davenport v. State, concerns a defendant's right to a fundamentally fair trial. In Davenport, the court held that a defendant charged with shooting her estranged husband was denied a fundamentally fair trial where 1. The district attorney had previously represented the husband in the divorce proceedings that were pending at the time of the shooting. 2. The district attorney was cognizant of information and incidents that occurred between the victim and defendant by virtue of his representation of the victim in the divorce proceedings. Now, what's interesting about this, if you guys are watching the YSL RICO trial, there's like, I don't know, it was like over 30 people were indicted. A lot have taken plea deals. There's less co-defendants sitting there now, but it's still a lot. It's a huge case. Fani Willis had previously represented YSL Mondo, who claims to be the founder of YSL, the organization that's the subject of this gang-related RICO trial. But YSL Mondo, and he says it was a prayer. He says he felt like it was a gift from God. He was not named in the indictment. So there's certain parts about this case, some of my interest in what's going on with the disqualification case has nothing to do with Trump, but what's going on with the YSL trial, which is a whole nother hairy nest, guys. If you haven't been following that, it's really interesting, but we're already on day like 39, 40, 41, and it's expected to keep going for like at least another 8 months. So if you want to throw away your next 8 months of productivity, check that case out. But it is just something that's been in the back of my head is, I think there's some type of conflict, some kind of questions I have about Fani's office. And it might not necessarily be about who she's dating, but to me, it was like, how did she pull this indictment forward against YSL? But in like 2019, I think 2018, she represented YSL Mondo. There's stuff that she knows that is protected by attorney-client privilege from YSL Mondo. And then she brings an indictment forward against his organization, but doesn't indict him. So just something that's been on the back burner while I go through this whole case that's totally separate from this case. But to me, it's kind of a bigger deal. But anyway, I digress. So where was I? And then 3, the district attorney sat on counsel's table for the entirety of the trial. Yikes. The court held that public policy prohibits a district attorney from prosecuting a case while representing the victim of the alleged criminal act in a divorce proceeding involving the accused. Both the facts and the legal principles in Davenport are far too remote from the present case for that case to be applicable here. The final case, and again, that is going back to what you guys pointed out in the chat, the conflict of interest is actually happening across the floor on the court, right? Because you go from the defense table to the prosecutorial table. So the adversarial issue is opposing parties now. It's not just like we're both sitting here and we both know something, we both represented the same client, and now we're both advocating for the same client. That wouldn't really be a conflict. The final category of cases relied on by the defendants involves cases where disqualification was found not to be proper. 1, a special prosecutor who accepted future employment with a law firm that previously represented a prosecution witness in a collateral matter was not grounds for disqualification because no conflict was shown. So Whitworth v. State, we heard a lot about that at the Senate hearing, and a little bit too in the closing. But the Supreme Court of Georgia has repeatedly held that an actual conflict of interest is required to warrant reversal for failure to disqualify. A district attorney's office investigator's close personal friendship with the victim was not grounds for disqualification. And 3, a prosecutor's statements to the media after a hung jury that the score is 35-1 for conviction. Now, this is important because, again, this is post-trial. This is at least after where we could have gotten an end goal. So with a hung jury, we're not getting that conviction as an outcome, but a hung jury is still an outcome of its own. It is, we can't give you a conviction. We can't come to that agreement. But it's got to end here. The judge says, you guys can't come to a decision. It's officially hung. It's like a tie, really. So, and that legally there's no legal conviction. So that's important because we haven't even had this RICO case officially kick off. And this is dealing with after a hung jury, after trial, after deliberations. That the score is 35-1 for conviction, and that there is, quote, substantial reason to believe the defendant is guilty, did not amount to either forensic misconduct or any other grounds for disqualification. None of these cases suggest that a district attorney may be disqualified based on anything less than an actual conflict of interest. Multiple Georgia Supreme Court cases clearly establish that Georgia trial courts are not authorized to disqualify an elected district attorney absent an actual conflict of interest. An appearance of conflict is insufficient. There are generally 2 recognized grounds for disqualification of a prosecuting attorney. The first such ground is based on a conflict of interest, and the second ground has been described as forensic misconduct. Under Georgia law, conflicts of interest have been found only where, quote, a prosecutor previously has represented the defendant with respect to the offense charged, comma, has consulted with the defendant in a professional capacity with regard thereto, or where the prosecutor has acquired a personal interest or stake in the outcome of the proceedings. No other disqualifying conflict of interest has ever been recognized under Georgia law. Moreover, as the Georgia Supreme Court again reiterated less than a month ago, that was February 6th, an actual conflict of interest is required for disqualification of a prosecutor. And they cite this quote here, the trial court did not abuse its discretion by failing to disqualify the assistant district attorney absent an actual conflict of interest. So wait, they must have reversed that decision then, if they're saying it supports their position. But yeah, we'll assume that reversed the decision then. So this has been unchanged law in the state for decades. In Blumenfeld v. Borenstein, the Georgia Supreme Court considered whether a trial court erred in disqualifying an attorney based on an appearance of impropriety. That resulted from the fact that 2 lawyers representing opposing parties in the matter were married. I think we looked at this paragraph yesterday. Yeah, that's interesting. You sleep in the same bed, you have pillow talk about, but you're both representing opposite parties in a case. Yeah. Imagine if one of them was like Terrence, how much pillow talk would go on about the other client. That'd be bad. That'd be so bad. The court recognized that although the issue has never been squarely addressed in Georgia, courts in other jurisdictions have rarely been willing to disqualify an attorney based on the appearance of impropriety alone, where there is no danger that the actual trial of the case will be tainted. The court reversed the trial court and rejected the notion that trial courts are authorized to disqualify attorneys based on the appearance of impropriety. The appellees have not shown us a case where a per se rule was applied to disqualify an attorney. So that's inherent, right? It is. You don't really need to, just by the nature of it, it just is. You don't need to make the argument any further than that. That's what per se rule means. On the basis of an appearance of impropriety alone. The Georgia cases cited by appellee do not stand for the proposition that a trial judge is authorized in Georgia to disqualify an attorney solely based on the appearance of impropriety. Significantly, the court did not restrict its language here to status-based conflicts, and the state of the law has not changed since. Since Blumenfeld was decided more than 40 years ago. Based on the state's reading of the case law, no appellate case in the state has, before or since Blumenfeld, ever authorized a trial judge to disqualify a prosecutor solely based on the appearance of a conflict of interest. So, this is really less an argument. This isn't really a direct argument against the defense, even though, they're kind of framing it that way. Well, they're not actually. Okay, this is actually, it seems like an argument against Judge McAfee, because Judge McAfee at the start of the disqualification hearing came out and said flat out that, I'm trying to follow the letter of the law, and going by the letter of the law, we're looking for an actual or an appearance of a conflict of interest. So this argument, to me, is really based right at our trial attorney, Scott McAfee. And they said, you're looking for the letter of the law, here it is. This concept has been reinforced in multiple cases since Blumenfeld. In Lyons v. State, the Georgia Supreme Court refused to accept a defendant's argument that the trial court erred in refusing to grant his motion to disqualify the district attorney based on an appearance of impropriety. We have a footnote there that says, these cases examine the question in a post-conviction context. At the hearing on this matter, the court inquired as to whether a different standard may apply pre-trial. No Georgia case has ever held that the standard for disqualifying an elected district attorney is different based on whether the question is raised before or after trial. So, yeah, at least they're acknowledging here. There's just no... Well, it's true, but this is one of those half-speaking type of things that you see in legal writing sometimes, right? So yeah, it is true that they've never held that the standard is different. But there's just no... You know, there's no adverse authority and there's no affirmative authority. There's neither. And here they're kind of like trying to say, well, you know, there's nothing that affirms that idea. Well, no, there's just no answer at all, which is slightly different. And then wait, I was actually up here. Where did that footnote start? Okay. The court reiterated that, quote, a theoretical or speculative conflict will not impugn a conviction which is supported by competent evidence. So again, we're dealing with post-conviction. While Lamb did not involve disqualification of a district attorney, in that case, the court reiterated that an alleged conflict must be palpable and have a substantial basis in fact. And then, so the decisions of the Georgia Court of Appeals are in accord. So we get back to Whitworth here. In Whitworth, the court affirmed a trial court's denial of a motion to disqualify. So in Whitworth, it's affirmed. They're saying, yep, the court was right to deny the motion to disqualify because there was no actual conflict of interest shown. The Supreme Court of Georgia has repeatedly held that an actual conflict of interest is required to warrant reversal of a conviction for failure to disqualify. A theoretical or speculative conflict is simply not sufficient. Every Georgia case that has addressed the issue has reached the same conclusion. In order to authorize a trial court to disqualify an elected district attorney, an actual conflict of interest must be proven. No prosecutor in the state has ever been disqualified on the appearance of a conflict. So, I think this is one of the strongest arguments as far as what I really think Judge McAfee is trying to consider, what Judge McAfee is focused on. What is my role? What is the power here? What is the standard? What is the letter of the law? I really think that the section we just read is the strongest part of this argument. And I also think it's why we get McDougald, Harry McDougald, Mike Drop McDougald responding first, because that was his whole argument. If you go back and watch, he got up there and said, everything I'm saying, I'm coming from a basis of actual conflict. He delivers his statement, he walks off. So yeah, that's why I was excited to see that reply be from him specifically, because this is the strongest argument and he bites right back at it. I did a little bit of reading. I haven't actually read the whole thing, so I don't know how well he bites at it, but. And then we get here the argument 4. So OCGA confirms multiple Georgia cases holding that an actual conflict of interest must be shown to disqualify an elected district attorney. The cases set forth above that hold on, what are you guys laughing about over here? The whole case is based on gossip. It's Terrence. It's Terrence Bradley. Wait, oh my god, no, not the freak-offs. Not the attorney freak-offs in Fulton County. One of those Diddy, did he call them freak? Yeah, the freak-offs. One of Diddy's freak-offs. Didn't that happen in Atlanta? What was the hotel that Cassie alleged? The Atlanta one. She cited it. She said one of the big times was in Atlanta. You never know who was there. So Chinzia and Erica are coming in here at the right time. We're talking about freak-offs. Let me get back to argument 4. The cases set forth above that hold the proof of an actual conflict of interest is required to disqualify. Sorry, I'm just like, Your Honor, we were just having a freak off. It's fine. There's no conflict of interest. Like, imagine that just becomes the argument. The cases set forth above that hold the proof of an actual conflict of interest is required to disqualify an elected district attorney are confirmed by the language of OCGA. That statute explains the procedure for the appointment of appoint a substitute. For the appointment of appoint a substitute. I don't know if my brain is fried or if we're missing a word here. For the appointment of a substitute. When a district attorney's office is disqualified from interest or relationship to engage in a prosecution. And I don't blame them. They had to file this really quickly if they typed something wrong. OCGA 1518.5 is cited again. The statute makes no mention of disqualification due to an appearance of a conflict of interest based on personal interest or relationship. This court must, quote, construe the statute according to its terms and give words their plain and ordinary meaning. And they cite Fontaine versus Signature Research. Why did they emphasize that was cleaned up? Just for this? Moreover, the statutory language has remained unchanged since the state's first codification of the common law, which took place on January 1st, 1862, when a solicitor is absent or indisposed or disqualified from interest or relationship to engage in a prosecution. The presiding judge must appoint a competent attorney of the circuit to act in its place. Oh, okay. Interesting. Well, when a solicitor, though, I don't know. I do think that a solicitor is, again, and this is because it's a small, unique circumstance. It's a novel legal question. Solicitor is a little bit different than a district attorney and special prosecutor, if you ask me. This language, as old as Georgia's statutory law itself, should guide the court. References to Caesar's wife. Okay, so that's where, so at the end of this clip, where this clip kept going, I think I'm right at it.
Sometimes the language can be what we're not accustomed to seeing, but there's
Caesar's wife.
They refer to the metaphor of Caesar's wife, and generally when that's used as a ethical standard, that's something that goes beyond just an actual conflict, right? Isn't the beyond reproach getting more into appearance world?
Is it getting beyond?
No, isn't getting into the appearance aspect of things when we're talking about Caesar's wife.
But I think it goes beyond that based on the language of the holding in that case, where it literally says that the individual had a personal interest in obtaining a fee by forcing a settlement in the civil case and using the criminal case as leverage. So that's not an appearance of impropriety. That is an actual conflict of interest in which arises because of the individual's personal stake in the end outcome of the case, Your Honor. So that's how I would differentiate, I guess, the representations of defense counsel as it relates to the standard or the burden that must be shown, and why the state would submit to the court, and the most recent ruling out of the Georgia appellate courts that an actual conflict is required to be shown.
So, and I actually should have let that play out. He just stands there and he goes on to a neck. He's like, okay. He just moves on. So, let's see. We're going to address what we heard there. This is in the response that I swear Fani Willis mostly wrote after the closing arguments. We're going to get to the Caesar's wife right here. So references to Caesar's wife in certain cases do not lessen the requirement that an actual conflict of interest must be shown to disqualify an elected district attorney. At the hearing at this matter, the court also referred to the occasionally invoked example of Caesar's wife. The language to which the court referred was first used in Nichols v. State. Quote, "The administration of the law, and especially that of criminal law, should, like Caesar's wife, be above suspicion and should be free from all temptation, bias, or prejudice, so far as it's possible for our courts to accomplish it." The court noted this language and questioned whether it suggests that something less than an actual conflict of interest could suffice to disqualify a prosecutor. The state has not found any case that has ever made such a holding, and in State v. Sutherland, the Georgia Court of Appeals went out of its way to reinforce the differing standards between prosecutors and fact-finders such as judges or juries. Shortly after quoting the Caesar's wife language found in Nichols and other cases, the court explained, Mr. Wilson's civil action is entirely separate from Appellee's criminal prosecution, and, assuming that Mr. Thacker is a partisan, he has not been shown to be such a partisan as would disqualify him from proceeding with the prosecution of Appellee. Quote, "While the prosecuting officer should see that no unfair advantage is taken of the accused, yet he is not a judicial officer. Those who are required to exercise judicial functions in the case are the judge and jury. The public prosecutor is necessarily a partisan in the case. If he were compelled to proceed with the same circumspection as the judge and jury, there would be an end to the conviction of criminals." So it'd be an unreasonable thing, a standard to adopt. Scott v. State. The record shows nothing to suggest that. In his handling of the prosecution of appellee, Mr. Thacker was acting in his personal or individual character, or for his personal or individual interest, but in his character as an officer of the law, specifically charged by statute to perform his particular duty. He was not employed by any private person to prosecute, and his acts in connection with the instant case were, quote, not with a view to the interest of any client, but alone to subserve public justice. The trial court erred in granting appellee's motion to quash the indictments on the grounds of Mr. Thacker's disqualification. So, they're citing, what was the full case? Sutherland versus what? Because they keep mentioning it here. State versus Sutherland. So Sutherland thus acknowledges the example of Caesar's wife cited in Nichols and other cases, but emphasizes that prosecutors are not held to the same standard as judges. Instead, prosecutors can only be disqualified in cases where they are acting on their own personal or individual interest, rather than in their character as an officer of the law specifically charged by statute to perform this particular duty. Now I want to pause here because we heard a lot of stuff in the Senate hearing yesterday that, although interesting, the Senate is a different type of forum. That's meant to deal with new legislation. Do we need to fix something as it exists? Do we need to write something new? We want the public to trust us and have confidence in what we do. And while we're investigating this Fani Willis subject, are we going to uncover something that we need to do better? And here we're talking about what happened on the courtroom floor. And I can't help but think the personal or individual interest, we heard stuff on the Senate floor yesterday about Fani Willis using public funds to pay for her own personal branding, her own reputation management, her own PR from public funds to build her personal brand. Problem with that is it's not on the record in the court. At least I don't remember that ever coming up. Maybe you guys in the chat can remember if while Fani Willis was on the stand, was she asked any questions about the public relations firm that she hired? I think, was that under Jeff DeSantis was the guy's name? I forget the company's name, something with a C. But there's nothing on that in the record for the judicial side of everything that's going on with Fani Willis. Two totally separate bodies. And if it's not on the record, it doesn't exist in Judge McAfee's purview. And unfortunately, I think that'd be one of the strongest cases for the defense, going to say that, yeah, it is a personal or individual interest, regardless not just of the outcome of the Trump RICO case, but the inception of it, from the inception. It's been a branding opportunity for Fani Willis through and through, and she was using public funds to pay the company to help her do it. But it's not on the record. So to me, what could have been one of the strongest things here for the defense, it doesn't exist as far as Judge McAfee is aware of. Again, that's if I missed it coming into the record. I really don't remember it coming into the record at all in court. But yeah, that's something we only heard in that Senate hearing, and that's a totally different forum. So Sutherland, and also it wasn't like, there wasn't someone that responded to it to be like, hey, that's not what this company actually does, right? There wasn't, Ashley was there as a witness answering questions. It's not the same way in a court where you get cross-examination. So Sutherland also invokes, yet again, the example of private prosecution. For example, contingency fee-based prosecution as an example of the sort of actual conflict of interest required for disqualification. Indeed, in every case the state has found involving disqualification of a prosecutor based on personal stake or interest, that personal interest has consisted of the prosecutor enjoying some direct pecuniary gain, that's a word you don't hear often, contingent upon the outcome of the criminal case. Without such a personal interest sufficient to wholly displace the prosecutor's role as an officer of the law, disqualification is not authorized. Yeah, so for here, I really think the strongest thing to show Fani Willis' personal interest at any timeline would be that personal branding thing, and it's not on the record. The defendants have not met their burden of proving either an actual conflict of interest. And let me clarify, I'm saying that because it was the billing for that service fee. It was billed to public funds. The county was paying for it. So, allegedly, according to Ashley Merchant. So, but she apparently uncovered that through a public records request. So, Argument 6. The defendants have not met their burden of proving either an actual conflict of interest or forensic misconduct on the part of the district attorney. So basically getting up to this point, and they did say at the beginning, we're not really going to focus too much on the forensic misconduct, but there's only two ways through the legal standard that, according to statute, that you can disqualify a prosecutor. And that has to be an actual conflict of interest. And everything we've read so far is really emphasizing the language is actual conflict of interest. There's no room to rework that and say a perception or appearance of a conflict of interest is enough. So up until now, that's what they've been arguing. And now we're going to see a little bit more about that second available legal standard. You know, forensic misconduct could be a reason that you disqualify a prosecutor. But in either case, they're arguing that the defendants have not met their burden of proving either of those things. For the reasons set forth above, the court should not disqualify the Fulton County District Attorney's Office from prosecution of this matter where the evidence before the court fails to demonstrate actual conflict of interest or forensic misconduct on the part of district attorney by a high standard of proof. To whatever extent the defendants allege that the district attorney received a benefit arising out of this prosecution, they have made no allegation and have offered no evidence that the district attorney has any improper, direct, and material personal stake or interest. And again, no allegation and offered no evidence. That's what I was just saying. We heard that is some tea from that Senate hearing, but it doesn't matter because it's not on the record over here in front of Judge McAfee. And this is a great, this little word here, this little phrase, they haven't made the allegation, they've offered no evidence, no record of it. There's nothing on the record. That's a tiny little sentence, but it's really strong. That the district attorney has any improper, direct, and material personal stake or interest in the outcome of these proceedings sufficient to authorize disqualification. So they cite the amusement sales and Whitworth again. The defendant's suggestions concerning what constitutes an improper personal stake or interest are both unsupported by law and, as the court rightly pointed out at hearing in this matter, entirely unworkable. Application of the actual legal standards, reiterated by Georgia courts and the statute as set forth above, leads to only one authorized outcome. The indictment should not be dismissed, and the Fulton County DA's office should not be disqualified. So first big name here, Fani T. Willis. And I'm telling you, that was this moment here. She got right up out of these closing arguments. She said, I gotta go write this better.
All right, thank you, Mr. White.
I'm telling you, she went and she immediately wrote this. She sat down and said, doing it again. Oh my gosh. So while we have that up, let me pull up Harry McDougall's response. I keep calling him McDougall. McDougall, having the D at the end of the name, like, really trips me up for whatever reason. McDougald. Let me see what you guys are talking about. Yeah, so you don't think you did. I think that's in reference to hearing. I really don't think anything about that brand management and billing to, you know, the county was mentioned at trial. It's just not on the record. Oh, hey, Chicken Little. And thanks again for the membership to TLA. Okay, so you got one of them. It's crazy because there's always so many people in his chat. So when you get 5 memberships, it's like really like a lottery chance, right? But yeah, I know he locks non-members out of the chat. So I try to get 5 people in there every time I'm in there. The Georgia Senate Ethics Committee is meeting today and hearing 2 ethics complaints about Fani. Yeah, so let me pull that up actually. I don't think it's live yet. Let me refresh 11 Alive. So what she's talking about here is separate from the Senate hearing yesterday where they purposely subpoenaed, they made the initiative to subpoena Ashley Merchant. But today we're going to have a meeting. It's an ethics meeting and it's open to the public. Like, I accidentally went into the Zoom. I clicked the link thinking it'd be the link to watch the stream, and it's like opening Zoom and like no one was in there yet. But if you guys want to go sit in the Zoom chat, it's open to the public. I can drop the link if you guys want. But 2 members of the public, so Stephen Kramer and the other guy is Mantell something. George Mantell, I think is his name. Gregory Mantell. So they filed individual complaints as members of the public to the Fulton County Board of Ethics. The one guy, he runs an investigative news service. His issue is, if you watched the Senate hearing yesterday, Ashley Merchant made mention of, hey, I filed some public records requests and they were denied. And I wanted to get some transparency into, you know, financial records, what certain officials are getting paid. And Dexter Bond denied. Well, Gregory Mantell also seems to have put forward those same records requests, and they got denied for him too. They're summarizing it here, 11 Alive, as Nathan Wade's invoices, other financial records. Sorry about the ads. that they refuse to release. So this guy is filing an ethics complaint about that. We heard that Ashley Merchant has a lawsuit open to force the release of those public records to fight the denial that she received from Dexter Bond. Then there's Stephen Kramer. It says he's a resident. I don't know. Like, this guy obviously works for a news company, Gregory Mantel. I don't know if Stephen Kramer is anyone more than just a public citizen that is bringing forth a ethics complaint. Asking questions about Willis and Wade's relationship, money spent on dates and trips, and how county funds were allocated. So the issue, his grievance is misappropriation, allegedly, of public taxpayer money. Now, what's interesting about something like that is it's not going to be a Senate panel listening to this attorney, Ashley Merchant, just talk about the records she had and any additional testimony she may be able to provide to the Senate, separate from the judicial hearing. This is a public forum. This is something, you know, if you have an issue with what's going on in your community, you should, as a resident, have the right to say, hey, I want to be heard. I want to bring this new issue to your attention. So that's what these two guys are doing here. I don't know if members of the public will go to it. Let's see. Where do we have the... I had the window open. I have to go and dig for the link. I think I closed it really quickly once the Zoom started opening. I was like, oh God. It's like, I'm not trying to go in here. Maybe Mantel had it. Let's see. So this is his news company, his news blog. Maybe he had the link. In any case, 11 Alive is going to have it on their YouTube channel. So that will be streamed live. But the minutes, I had the minutes open to it. And they have other issues they're going to cover first. Existing issues they're going to go over first. So really the point of what I'm getting at, now that you know what that meeting's going to all be about, it might not start. The meeting starts at 10 a.m., but they have other issues that they got to talk about first. So I don't know if they'll even get to the two people that want to bring forward their grievances with Fani Willis until, you know, maybe noon. If it happens at a good time, we can definitely look at that, though. Yeah, pay cash, people, and under no circumstances accept a receipt. Do you ever go to Walmart now and they like want you to enter like your phone number and email, and like they have the self-checkout? But there's all those jokes about people like swiping stuff through self-checkout, not actually paying for it. And all I can think is like, oh, well, someone just stupidly stealing something at self-checkout, and then, oh yeah, I'll enter my phone number or email me the receipt. And now they know. Dumb criminals. And then does the judge get to see these briefs before he makes... Yeah, so these briefs that we're looking at are filed in relation to the judicial hearing, right? Not the Senate stuff. This is to the court. This is to Judge McAfee's court. So he gets to see them. In theory, he should read them. If you guys ask me, I think Judge McAfee has a serious poker face. I think he is looking to look for, you know, the case law, the precedent, and make a good decision. You know, sometimes with cases like this, you can kind of get the vibe that the judge is gonna lean one way or the other before he even hits the gavel at the beginning of the case, of the hearing. So, with this, I don't really think that's the case with Judge McAfee. So, even though he might not even look at these briefs, and he may kind of already know what they say, I do think this written brief that we read delivers the information that the state failed to deliver really well and charismatically on Friday with closing arguments. I do think it was delivered much better in the writing. But at the same time, it was technically stuff that Judge McAfee was already told, right? It's just really written way better and clean compared to the way it was delivered on Friday. So, oh, that's awesome. Yeah, I feel like my name is kind of an issue. I think when people type Cat Williams comes up, so no one will ever be able to find me, but that's awesome that YouTube actually recommended that. And then let's see. Okay, Erica, if you want a membership, we gotta wait for them to schedule something, and when there's only like 10 people in chat, I can just blast it out. And do you think Georgia bar and state government will go for their licenses? I feel like if they don't, then the whole state will look questionable big time. I think if anyone, I don't know. I think Terrence Bradley has to be on the radar because he said, like, hey, I spoke to the bar. I was on the phone with them. So, it's already on their radar, right? Things don't get done unless something is tabled, right? Something has to actually trigger something to be done. Most initiatives or happenings don't just pop up out of thin air. Someone has to kind of like light the fire to get things started. I don't know. I'm sure there's plenty of people filing bar complaints already, but you know, a lot of bar complaints are going to be written off as kind of frivolous. And then if they're getting so many from both sides, and there's also, I think it was a brief filed by a pro-democracy organization. They often write like amicus briefings for courts. They want them to consider things that protect elections. They wrote something to Judge McAfee as well, saying, hey, you know, as an organization, we don't think that there's a conflict of interest here that warrants a disqualification, and this case that this whole disqualification motion is coming from, it's too important of a case for this to be the case that you decide to disqualify someone in relation to. So there's organizations already, this is a huge case, guys. There's already organizations writing their own filings to kind of urge Judge McAfee to make a certain decision. I would imagine the same is already being done with individual bar complaints. I'm sure individuals on the internet have also gone and tried to file their own bar complaint, because I think anyone can go and file one. But whether they take action or not, I don't know. Then these kinds of dog with a bone fights often end up turning on them. This unwillingness to let the court decide is going to come back on Ashley. She's at too far a moment. And that's what I'm thinking. So, and again, I have to like keep remembering that everything that happened on the Senate floor is separate. It's not on the record in the judicial case. What's on the record in the judicial case, we don't actually know everything that was submitted as exhibits. We kind of got a hint at what some of the exhibits were that we may not have been able to see in full in the courtroom, but we know that they were at least submitted in full to Judge McAfee for him to consider. And we know he has all the text messages. I'm sure he has like those invoices. I'm sure they have that summary of the cruises, because we know that she filed that in her second revised motion to disqualify last month. And I think for Ashley Merchant, like that kind of stops there. I'm not sure that she's done anything further. But here where we're getting a back and forth, we have Fani rewriting the closing arguments in a cleaner way. And now we're getting Harry McDougald writing his reply. And he's writing in his reply, we're going to see, we expect other co-defendants that their attorneys are also going to submit more. So it's possible we may have a response to the state supplement here filed by John and Ashley Merchant, their joint law firm. So maybe she hasn't stopped with the judicial side. But for me, I'm having a hard time remembering, like, hey, yesterday, everything we heard about, if it wasn't already on the record in Judge McAfee's court, that was a separate forum. But yeah, I don't know. All I know is I would love someone like Ashley Merchant doing research on like a really important case. Like I think like she mentioned she did post-conviction work, you know. If she did that type of research and spent the time she spent advocating for Michael Roman in this case, for this motion to disqualify, and everything she presented, all the public records requests, she said, hey, the state may have had these records, but I went and requested them on my own, so I would be able to put them forward. She took the time to do that. And all I can think of is, you know, when there's a wrongful conviction case, when there's someone that was falsely accused and falsely convicted, man, I wish everyone had the receipt puller or someone that would spend months. As far as I know, Michael Roman has a GoFundMe to help pay for his legal fees. So I'm kind of guessing that Ashley Merchant may not, just a guess. The GoFundMe could just be to offset things, right? Doesn't mean that someone isn't able to pay the outstanding fees to their attorney. It could just be to offset them even though they're already paid. But I feel like she's doing that research. She's really going in and putting the hours in to do it. And I want people to advocate like that for, sorry, this is playing. I want people to advocate for these cases. Things like the Innocence Project, you know, you hear false accusations, falsely accused. These people lose 20 years of their life, 30 years of their life in prison. And it's like, man, I would love to see what we saw yesterday. Someone come in with a binder, lay it on the table and be like, look, this person is on death row for a crime he didn't commit, and the evidence proves it. You know what I'm saying? Like, I just think of that tenacity and wanting that in another case for another defendant. Yeah, it's just a huge case. Oh, and Duddy, that's awesome. So Duddy K says, this is Judge McAfee you're speaking about. He is fair. I've seen him before try other cases. He seems really interested. Like, I can picture him being an appellate court lawyer. And then Jimmy, the tricky part is, how do you disqualify Fani without making it easier to disqualify other DAs in the future? So what's interesting is I think that Senate hearing yesterday, if they're thinking of new legislation or amending what currently exists, I think the Senate side, right? This is separate from the judge who's actually the one tasked with making this decision to disqualify or not disqualify. But the Senate, they can say, hey, we have certain rules in place. There's the county process. There's these rules and regulations there. It's codified into law for employees of the Fulton County. So if an ADA comes on, that's an employee. And there's certain things that criteria that have to be met and processes that have to be followed. Well, is there something that we can put into law that says if someone comes on as an independent contractor to be a special prosecutor for a certain case, you know, what kind of criteria can we carry over? Maybe we decide we don't want to say you can't have a private practice because we don't want to shrink our pool of available special prosecutors, right? I think the bigger question here isn't making it easier to disqualify DAs in the future, but if we go over to what the Senate's tasking themselves with, how do we make sure there's no opportunity to throw spaghetti at the wall and claim that there's a conflict of interest, or how do we prevent the conflict of interest in the first place? So if there is a conflict of interest, it can be prevented by hiring criteria, the process of appointing someone in the first place. How do we make a new law that helps regulate that and prevents this problem, prevents it from being an issue in the future, while also not boxing out the pool of people that would ever want to be a special prosecutor, right? Because there's a limited amount of people that would be, you know, qualified and willing to be a special prosecutor for any given case. So if you were to say like, hey, we're going to take the same laws that currently apply to public employees. If someone is going to be employed as an assistant district attorney, they can't have a private practice. Well, maybe we'll take over all the other rules, but we'll leave that rule out. If you want to be a special prosecutor, you can still maintain your private practice, but we do want to follow this other approval process before you get seated and chosen and signed in. So I think the bigger question here, Jimmy, I get what you're saying, but I think that's actually the bigger question for the Senate if they want to kind of take preventative measures and put a statute in place. But they have to do it in a way that doesn't make it so very too small of a pool of people could or would want to be a special prosecutor. So let's go over. Let's see. I had it open already. All right, so we're going over to Harry McDougald. That's the guy that they said was like mic drop because of the way he walked away from the podium. This guy over here. Was this the video? Yeah, this guy.
They should be disqualified and the case should be dismissed.
And his is shorter, thank God, because I'm losing my voice. It's 10 in the morning and I'm already croaky. But this is just on his behalf here for his client, Jeffrey Clark. Jeffrey Clark's reply to the state's supplemental post-hearing brief. Comes now Jeffrey Bossert Clark, defendant in the above-titled matter, and submits his reply to the state supplemental post-hearing brief filed March 5th, 2024. And again, so this was filed yesterday, and thanks. I don't see Barbara in the chat yet. She's West Coast, but she had sent over an article that had this document in it. So shout out to Barbara. This was published yesterday. This was filed yesterday. And that seems quick, but at the same time, it's again going to reiterate some of the same things we heard in closing arguments. So they probably already had a lot of this framework ready to polish it up, add in exact specific things that may have been said in court and in the supplemental brief filed by the state, clean it up, fire it away. So comes now Jeffrey Bossert Clark, defendant in the above entitled matter, and submits his reply to state supplemental post-hearing brief filed March 5th, 2024. In its brief, the state argues, 1, that the standard of proof should be higher than a preponderance of the evidence, and 2, that an actual conflict of interest must be shown, 3, that the district attorney must be shown to have a personal pecuniary interest in conviction. So see, we're already getting bold, because that is the point in the timeline that the state focused on, is that if there is the personal interest, it can only relate to that moment in time, the result, the outcome, the conviction. as distinguished from other stages of the proceeding, or a personal pecuniary interest in the prosecution as a general matter. And 4, that defendant's evidence is insufficient to meet these standards. For the reasons set forth below, the state's argument are without merit. So, argumentation and citation of authority. Before turning to the merits of the state's supplemental brief, it's necessary to observe that the district attorney has ratified the perjury of Nathan Wade. So they're firing shots at Nathan Wade. Nathan Wade obviously lied under oath in his testimony on February 15th, 2024, when he was, wow, that's almost a month ago now, when he was attempting to explain his obviously false interrogatory response in his divorce case. We are now 20 days past that testimony. In that intervening period, the district attorney has said and done nothing whatsoever to either disavow Mr. Wade's perjured testimony or require him to correct it. And now that's interesting, right? Was Nathan Wade really even mentioned in the supplemental brief? I mean, maybe there's like a line where they're alleging in their motion that there was a conflict of interest because of whatever. But there was no argument put forth to dispute anything about what Nathan Wade said or any relationship issues. The state supplemental brief was almost entirely focused on, here's case law that goes to the issue must be an actual conflict of interest. And we had 4 arguments based on how Judge McAfee should only look for an actual conflict of interest. And they didn't really attack any of these underlying things on the record, which may be a misstep. Because Judge McAfee did ask questions during closing arguments. Well, what exactly is the issue? Like, what threshold is it? If I give you a stick of gum, is that an actual conflict of interest? Am I now giving you undue gifts? And unfortunately, John Merchant, he had the opportunity to be like, anything above $100. And he didn't say that. He was just like, well, no, not a piece of gum, but something larger, like a vacation. There is a statute, there is processes that say $100 gifts. You're supposed to report that. And the defense, under John Merchant, he missed his opportunity to give Judge McAfee what he was asking for. But at the same time, the state didn't offer a counter either. They just kind of let it go and ignored it. And it's a huge elephant in the room that Judge McAfee is explicitly asking for both sides to address. And I think in his courtroom, if he has a question, your job should be to answer his question. That just seems like the type of judge he is. But state didn't address it in their supplement that we just read. So we are now 20 days past that testimony. In that intervening period, the district attorney has said and done nothing whatsoever to either disavow Mr. Wade's perjured testimony or require him to correct it. This is a spectacular breach before all the world of her duty as district attorney to faithfully and impartially and without fear, favor, or affection discharge my duties as district attorney, and the duties of candor to the tribunal under the Rule of Professional Conduct 3.3. Now, we heard him bring these arguments up in closing. The reason for this state of affairs is obvious. It is in the district attorney's personal, individual interest that Mr. Wade's perjury go uncorrected. Miss Willis has ratified Mr. Wade's perjury by not repudiating it as her duty requires. The district attorney's professional judgment has not been merely impaired by her conflicts of interest. It has been corrupted beyond redemption. So, strong language here. Standard of proof. The state argues that a preponderance of the evidence standard is too low for disqualification of a district attorney. At the hearing, Mr. Clark identified 6 separate categories of disqualifying conflicts of interest, only one of which is subject to any conflict in the evidence. So we've got 5 that are not conflicted. They're just left to be standing as fact. And we'll go over the one that is conflicted here. The one category subject to a conflict in the evidence is the extent of the financial benefits received by the district attorney from Mr. Wade. The evidence that Mr. Wade furnished the district attorney with expensive travel and entertainment are credit card statements of undisputed authenticity. The contrary evidence, so we have the charges, and then we have the explanation of how those charges broke down. So Nathan and Fani, they said, hey, yeah, he billed it all on his card because he used his travel agent, but I would give him my half back. So McDougall's going to throw holes in that. The contrary evidence, so that explanation, relies entirely on a story about totally undocumented cash reimbursements that magically netted to 0. So no paper trail, but just believe us, it's 0. It relies entirely on the testimony of Mr. Wade, an obvious perjurer, and Miss Willis, a witness with a motive to lie, whose testimony on the topic strains credulity. The evidence is sufficient under any standard of proof to find the district attorney received prohibited gifts from Mr. Wade. And remember, prohibited gifts is stuff above $100 that you don't report, or it could influence, or it's given in the course of influencing, potential or future employment with the county. So would this influence my appointment or my contract with the Fulton County government to sit as a special prosecutor and bill $15K a month or $35K a month, depending on what point in time we're talking about? So that would be where we're getting prohibited gifts. And has a disqualifying financial conflict of interest in the investigation and prosecution of this case. We expect that other defendants will be rebutting the state's arguments on this point in greater detail. So, hey, we're not going to go too much into the disqualifying financial conflict of interest. We expect other defendants will be rebutting the state's argument on this point in greater detail. Now, this is why, if you heard me say we might get other things from Ashley and John Merchant, I think this might be who McDougald is referring to, because Ashley is really the one that went and asked for all those financial records and pulled those invoices. It would make sense that the Merchant law firm, was the one that rebutted with a focus on the financial conflict of interest, just because they're the ones that went and pulled the invoices, the credit card bills, all that financial stuff. So I think it was Erica Dixon that mentioned Ashley being going too far. We haven't really heard from her out on the judicial floor since really John Merchant did the closing. We haven't really heard from her in the courtroom since the second time Terrence Bradley was on the stand, and she was really flustered because he's just like, I don't recall, it was just speculation. But I do think highlighting here, this is what I was saying, I think we might see a filing from the Merchants on the financial issues. So I'm not sure I'll read it if it comes out, but I'll share it if I see it. Moreover, importantly, for the purposes of this reply brief, the state makes no attempt to rebut any of the other grounds of disqualification offered by Mr. Clark. And I do agree that that was a misstep. They should have had some of that stuff in the supplement. 1, the district attorney's personal and political ambitions. 2, a complementary pattern of deceit and concealment of the relationship and the money. 3, the speech at the church. 4, the motion for protective order filed in Mr. Wade's divorce. And 5, the conduct of the state's defense of the motion to disqualify. These conflicts all rest on undisputed facts. Even if the standard of proof were metaphysical certitude, it would be met as to these 5 types of conflict of interest. So he's saying, even if the standard of proof was 100% beyond a doubt, absolutely, you can't argue otherwise, these 5 things, not this one financial thing that's, maybe there's room to poke at. These 5 things are absolutely certain. Actual conflicts. The state next argues that an actual conflict of interest is required rather than an appearance of impropriety, and that the required interest must be financial and that it must be in conviction. So, limited in scope and only to a certain point in time. There are compound errors in these arguments. First, and this is why I was saying it's so important that McDougald is the first one to respond, because he's the one that got up there and said, Your Honor, I'm going to start with the highest standard and just go only on actual proof of conflict of interest. Actual conflict of interest. And that's who's writing this first reply. So first, Mr. Clark's argument at the hearing assumed the actual conflict standard applied. That's his client. So basically my argument at the hearing assumed the actual conflict standard applied. The state never attempts to answer the argument that the evidence shows a half dozen actual conflicts of interest, 5 of which rest on undisputed facts. Second, the state attempts to disentangle what it claims are inapposite authorities relied upon by defendants, but in doing so itself conflates the standards for disqualification of prosecutors with those for post-conviction relief based on a claim of ineffective assistance of counsel, of conflicted defense of counsel under the 6th Amendment. And that was, if you were here from the beginning of this video when we were going through the state's response, that was one thing that I really focused on. It was kind of like a gray area. Yeah, there's a limited number of cases, but we're talking a lot about a post-conviction moment in time. Here, we haven't even gotten to the beginning of the Trump RICO case. The jury hasn't been sat. We're dealing with a disqualification motion taking place before the case really kicks off. And here, I think McDougall's challenging that too. So, Lamb v. State, which is what was cited in the supplement, was a case of the latter type in which the defendant, who raised no objection at trial, was required to show that the conflict adversely affected his lawyer's performance by depriving him of the undivided loyalty of counsel. While criminal defendants are not entitled to pick their prosecutor, so we're agreeing with what the state says in their supplement on this point, they are entitled to an unconflicted, disinterested prosecutor who does not operate in violation of their statutory oath of impartiality or the rules of professional conduct. The court held, so this is a different case, the Young v. Vuitton, that was also cited in the supplement. The court held the requirement of a disinterested prosecutor is consistent with that trend, since a scheme injecting a personal interest, financial or otherwise, into the enforcement process may bring irrelevant or impermissible factors into the prosecutorial decision. As evidence for this trend, the court in footnote 19 cited Brotherhood of Locomotive Firemen and Enginemen v. United States for the proposition that the appointment of interested prosecutor was a due process violation. Moreover, quote, courts have an independent interest in ensuring that criminal trials are conducted within the ethical standards of the profession and that legal proceedings appear fair to all who observe them. Now remember, state statute here, ethical standards as far as what could disqualify a prosecutor in the state of Georgia is, the conflict of interest. They're arguing whether it's actual. The state says it must be actual. McDougall says it doesn't need to be actual, but I'm arguing it is an actual conflict anyway. And then the second legal ground would be the forensic misconduct, which some of the co-defendants' attorneys are alleging that speech in the church. It said, God wants me to bring this prosecution forward. We have a 95% chance it's going to be a conviction, that those things were forensic misconduct. So it must be fair to all who observe them. Unlike the post-conviction Sixth Amendment ineffective assistance of counsel cases, quote, if the assigned prosecutor has acquired a personal interest or stake in the conviction, the trial court abuses its discretion in denying a motion to disqualify them, and the defendant is entitled to a new trial even without a showing of prejudice. Thus, if the disqualification motions are denied, an appellate court finds that the district attorney should have been disqualified, then any defendant convicted would be entitled to a new trial without any showing of prejudice. The state also argues that the only interest which is disqualifying is a personal interest in conviction. This ignores that a prosecutor's statutory duty of impartiality inheres in every official act they take, not just conviction. The district attorney is controlled by the public, and I think it was a flaw in the supplement to focus on that conviction moment in time. I think they emphasized it. They added emphasis to it. And they could have weaned that back down a little, in my opinion. The district attorney is controlled by the public interests, and while these interests require the conviction of the guilty, they forbid that of the innocent. The Solicitor General draws the bill of indictment, examines the witnesses, not with a view of the interest of any client, but alone to subserve public justice. If in his judgment the facts stated do not amount to a violation of the criminal law, he will submit no indictment. And then they're emphasizing this here, so McDougald's emphasizing. The whole proceeding, from the time the case is laid down before him, where an indictment is demanded, until the rendition of the verdict, is under his direction, supervision, and control, subject, of course, to certain restrictions which the law imposes. So they're citing Hicks v. Brantley here, and they also say C. Young. And they, in parentheticals here, injections of financial interest, quote, into the enforcement process violate the requirement of a disinterested prosecutor. The enforcement process has a milestone at the point of conviction, but the process obviously begins earlier. Additionally, it continues to sentencing and even arguably to post-conviction proceedings as well. In Nichols v. State, which we've seen cited in the supplement, and its companion case, Hughes v. State, the indictments were to be quashed if the personal interest existed when the case was presented to the grand jury. We've got an emphasis here. So they're citing two cases that the indictment should have been quashed if personal interest exists when the case was presented to the grand jury, as it did in this case. Here, Mr. Wade was paid over $650,000 over a 2-year period, beginning long before the indictment and long before any conviction, and the district attorney received gifts from him during this period. She therefore had a personal interest in the case that was operative at the time of indictment. The state, so remember, he already was invoicing for his cap of $15,000 a month for November and December, when his first 2 months he was appointed. Then the new year started, he has a break between contracts, and the contract comes back, and this is something that really got broken down yesterday in the Senate hearing, But the information, as much as was not denied by Dexter Bond with the public records, Ashley does have some information into these invoicing. She has a receipt of the monthly bills where you can see this month was $35,000, this month was $34,000, November was $15,000, the cap at that time. So there is evidence in the record in the judicial part of this in front of Judge McAfee that shows he was getting paid this money before the grand jury was even impaneling jurors. So that's what McDougald is talking about here. So he's getting this money, and his contract was already upped after 2 months from a $15K a month cap to a $35K a month cap after his first 2 monthly invoices. That's all before the grand jury was starting to seat jurors the following May. So here Mr. Wade was paid over, and I think, honestly guys, I think this is one of the strongest points just because it involves that contract. I think there's certain things here that Judge McAfee doesn't care about, but I think this is one of the things he's trying to nail down the timeline for. Because it's a payment, it's a contract, and there's a timeline to it. There's some case law and statutes about it, and the county, under the DA, Fulton, Fani Willis as DA, is signing off on these payments. I think this is really important because I think this is what the judge cares about. And they didn't really get into this in the state supplement. They ignored it. They should have addressed it because now the judge only has one argument on one side to go on. And maybe we'll get another reply from the state, right? It doesn't mean it ends here. They've got a week and a half to write something else. So here Mr. Wade was paid over $650,000 over a 2-year period beginning long before the indictment and long before any conviction, and the district attorney received gifts from him during this period. She therefore had a personal interest in the case that was operative at the time of indictment. The state's suggestion that this does not matter because the interest must be in conviction alone should be rejected because it is premised on the false notion that prosecutors have no duties of impartiality at any other time in the progress of a criminal case. And you guys know me, I like to be highly critical of prosecutors. I think one of the only instances I can think of where I'm like, hey, I like the prosecutor a lot more than the defense is the Courtney Clenny case. That trial hasn't started yet, so I'm only basing that on what I'm aware of. But I like the way that the state is operating much better than the defense attorneys. But otherwise, you know, I'm personally inclined, and if you're new to this channel, you should know that I like to be more critical of the prosecutors. I like to be more critical of the state because that's the government, right? And the Bill of Rights gives individuals rights. If they're a criminal defendant, they have more rights. So in general, in the effort of wanting more people to have a fair shot when it's their day in court, what I highlight here, that prosecutors, you know, this implication that the interest must only be in the conviction period. We must only take interest in these issues once the conviction's actually happened. I agree that that type of thing should be rejected because it's premised on the false notion that prosecutors have no duties of impartiality at any other time in the progress of a criminal case. I personally do not want more things to go to conviction and have to go through a post-conviction relief period just to get properly adjudicated. I really hate seeing a bunch of cases where, hey, after 5 years of appeal work, we finally get something overturned because it was a bad conviction. I really don't like to see that, and it's something we have way too many instances of in this country. And so my criticism has to go, in general, not to this specific case, in general, to the prosecutors, because they have the power, and they're supposed to be impartial. They're supposed to pursue justice, not convictions. So that's my tangent if you're new to this channel. The state argues at page 14 that it has found no cases of disqualification based on personal interest that did not involve a pecuniary interest in conviction. The state has apparently failed to notice one of the principal authorities relied upon by defendants, McLaughlin v. Payne. And McLaughlin, so they're saying you didn't even try to tackle this case that we focused on. In McLaughlin, there were not one, but 2 non-pecuniary conflicts that required disqualification. The first was the conflict between the district attorney's duties as a witness and an advocate at 611, and the second was that his daughter's close relationship to the victim gave him a personal interest in the case. The state's argument about what Georgia law regards as a disqualifying conflict of interest is without merit because it is contrary to binding Supreme Court authority. Lastly, the state makes frequent reference to the district attorney's status as an elected constitutional officer, referring to her as being elected 20 times in the supplemental brief. The state suggests that her status as elected should make the court more reluctant to disqualify her. In fact, however, Ms. Willis's status as the elected district attorney subjects her to an elevated, not a lesser standard of conduct, that of Caesar's wife. And that's tough because, and I'm making these criticisms here as from the framework of what I think Judge McAfee is looking for. And, you know, they're going right into what Judge McAfee was already intentionally bringing up during closing arguments. This notion of Caesar's wife and what that implies. And McDougald goes and says, hey, yeah, the Caesar's wife standard. And unfortunately, the state was kind of like, no, we reject that. So, I don't know. Personally, if you got to pretend to be in the seat of Judge McAfee, I think McDougald's coming in with the right focus on the things that Judge McAfee wants to hear an argument about. That's just me. That's my interpretation. My guess, because I don't know. 3, impaired professional judgment as a result of actual conflicts. A lawyer's conflict of interest is not waivable and is disqualifying when it impairs the lawyer's independent professional judgment. So they cite the rule of professional conduct 1.7. Everything the state has done in this case in response to the motion to dismiss or disqualify has demonstrated profound impairment of the district attorney's professional judgment. The first response of the state was a speech at the Big Bethel AME Church, in which Ms. Willis violated her public duty as a prosecutor under Rule of Professional Conduct 3.8 in order to advance her personal interests and those of Mr. Wade, an actualized conflict in which she preferred her personal interest to the detriment of her professional responsibilities. The second response was the motion for protective order she filed in Mr. Wade's divorce. In that filing, the district attorney and remember, so going back to the supplement we read today, filed by Fani Willis and the state, they deferred. They said, hey, we're not going to get into this financial misconduct thing dealing with the church, the Bethel AME Church. We're not going to address it in this supplement. Which maybe they should have. The second response was the motion for protective order she filed in Mr. Wade's divorce. In that filing, the district attorney violated Rule of Professional Conduct 3.4 by abusing the power of her office to threaten her boyfriend's wife with criminal prosecution to gain advantage for herself and her boyfriend in her boyfriend's divorce. This is also an actualized conflict of interest in which she advanced her personal interests and those of Mr. Wade to the detriment of her professional duties. Her third response was the written filing on February, and I think, yeah, it was MacDougald that brought this up, so he brought this argument up in closing too, because I remember he called, maybe I have it wrong, but it is Jocelyn Wade, right? And he was referring to Miss Joycelyn Wade. So he did, this is a short paragraph here, but I think he did kind of delve into this in his oral closing argument on Friday. Her third response was the written filing on February 2nd, 2024 in this case, in which she stated unequivocally that there was, quote, no evidence that she had received any financial benefit from Mr. Wade. This was false, and the state knew it was false because it came 2 weeks after Mrs. Wade filed a response to Ms. Willis's motion for a protective order, attaching copies of Mr. Wade's credit card statements showing he spent over $10,000 on travel with Ms. Willis, a filing that prompted intense national news coverage that surely came to the attention of the district attorney's office. This, especially on the back end here, we know that she has a PR person being billed out to specifically look at the value of news stories about her. This, again, that's not on the record in the court. That's just us with the tea here, looking at this case on YouTube. This was another actualized conflict between the district attorney's personal interests in concealment and cover-up of her and her office's public duties of candor and impartiality. The fourth response was to falsely accuse Ms. Merchant of making knowingly false accusations against the district attorney and Mr. Wade. And we had that on the stand, right? We had Fani Willis. It was one of the first things she said, like, you lied, like, this is lies, and she's holding up the motions, the filings. The fifth response was to allow Mr. Wade to tell ridiculous lies on the stand about his false interrogatory responses, and then failed to correct the perjured testimony. This was a flagrant violation of the district attorney and her entire team's duties of candor to the tribunal under rules of professional conduct. They breached their public duties to serve the public interests of the district attorney and Mr. Wade. And they have a footnote here. We note here that lead counsel for the state in defending the motions to dismiss and disqualify, Anna Cross, has disappeared from the case. She did not attend the last 2 days of the hearing and is not even CC'd on the state's courtesy copy emails to the court and counsel. Now, she wasn't on she wasn't part of that filing, but really that filing was only signed by Fani Willis, the supplement, Adam Abate, and John Wooten, Will Wooten. So she technically wasn't on that supplement, but only 2 names besides Fani were. But I had questions about that because she wasn't present. If you guys watched the, let me see if I grabbed a screenshot of it to make sure I wasn't crazy. And now I don't see it in my files. But when we were watching the closing arguments, Anna Cross was on the Zoom screen. They showed the Zoom screen briefly and who was in attendance over Zoom, but Anna Cross was there. And I made a comment. I was like, oh, like she's over on Zoom, so maybe she couldn't be here to deliver this closing argument in person. And maybe she wishes she was because of the charisma, the wind that left the sails of John Floyd while he was delivering his closing arguments for the state. So this footnote was a little confusing to me, unless they've had 2 other hearings on Monday, Tuesday, or Wednesday of this week for whatever reason. But I didn't see any news about that. So I don't know. This footnote, she's absent from the supplement, and if she's not CC'd on emails, that's another thing. But she was on the Zoom for the closing arguments. 6, Mr. Wade's obvious perjury remains uncorrected to this day, and therefore stands as ratified by the district attorney. Mr. Wade, the perjurer, so now he's Mr. Wade the perjurer, remains lead counsel for the state in one of the most prominent and closely watched cases in the entire United States, if not the world. Each of these responses show profoundly impaired, if not utterly destroyed, professional judgment, and the sacrifice of public duty to personal interests. The district attorney and her office should be disqualified and the entire case dismissed. Respectfully submitted this day of March 2024. So McDougald is the one who filed this on behalf of his client, Jeffrey Clark. Let me double check. Do we have... I don't think I see a live video yet for that hearing. Again, so that hearing for the ethics, that stuff starts at 10 a.m. Eastern time. It's 10:29 Eastern time. If you're not in this time zone, it's 10:29 Eastern time right now. But they have other matters that they're going to talk about first, right? So it's just because it starts at 10 doesn't mean they're going to be doing the 2 members of the public that have a grievance against Fani Willis. That might not start for like an hour or 2. But I will keep updating on that and probably try to close this out quickly. If I did set up a redirect to Nicholas Starrow. He's an attorney. He has a fun accent. He covers a lot of the YSL trial days. But I noticed he was going through the Senate hearing from yesterday. So if you missed the Senate hearing from yesterday or you wanted to rewatch that, I do have this set to spill over to redirect into that channel. You guys are welcome to not go forward with that if you want. I've never used the redirect feature before, but in a few minutes after we get through these comments, that's where this is going to redirect. If that motion hearing, that ethics hearing starts up before I have other work to do, I might pop up and do that live. If not, it's going to be on 11 Alive, the local news channel, their YouTube channel. Well, let's see what you guys are talking about. Yeah, the metaphysical, I was like, oh my god, we're getting like really philosophical here. Let's see, I think we were up here. So Deddy says the poker face is strong for talking about Judge McAfee. And just like they're watching Fani, she's about to find out some folks are digging on her. Everyone has a past. And it's like once it starts, right? Once we put out one piece of dirty laundry, the neighbors got to go out and put their laundry up. And then, you know, it's the back and forth constantly. The can of worms is open, the toothpaste is out of the tube, all of those sayings. I find her approach on behalf of these defendants dogmatic and a reflection of her and her husband's character. So I don't really, like, I feel like her husband is more of like this, I don't know. Let me say this the right way. I feel like she was able to speak and say more at the Senate hearing because it's just a different forum, right? You're not the attorney questioning a witness on the stand. I don't really look at her as like as a trial attorney. I really look at her as like a bookworm. And I don't know. I know this isn't the case. This is a big case that she's representing. But I really do. I'm going to stick to my guns here. I'm going to say I really hope that in the post-conviction work that she says is her focus otherwise. That she's out here pulling those receipts and bringing binders for all these other clients that aren't a Michael Roman. Jeffrey and Clark came in hot. Oh yeah, this was the guy that was flipping the pages hard, wasn't it? That was McDougald. He said, "Shoop, shoop." And then, hey, Blue Queen TV. And then Chicken Little says, Ethics Committee decided not to hear complaints about Fani. They don't have jurisdiction over Fani was the reason apparent. Okay, so that's not happening then. Sweet. So I just said all that spiel like 2.5 minutes ago. And here's Chicken Little's like very important comment that the Ethics Committee is not hearing that. 180 people here. Please don't forget the like button. Hit the like button. Man, so imagine we pull up this hearing and there's no tea in it. It's just like general course of business. And then, Kat, the burden of proof is on the side of the defense for this hearing. Yep, the DA does not need to defend anything not proven by the defense. Speculation and theory does not need to be disproven. That you could argue that, but I do think I think Judge McAfee has signaled that he's looking for specific answers about things in his decision, and I do think it's just a strategic misstep because of the judge, because of what the read I get of the judge, and they probably have more experience with him than I do. But from what I'm aware of with him, when he's coming out and explicitly asking a question about certain things, I feel like that needs to be addressed. And the judge did have explicit questions about, the dollar amounts, the timeline, the use of it. So I do think that it could be, it's a choice, right? Risk versus reward, it's a decision. So you could call the one play and say, hey, since it's not our burden of proof, we're not going to put this stuff in our supplement. I think on the alternate, the strategy I would look for is, hey, the judge wants to know this stuff. This is what the judge is like really weighing and leaning on as he's making these considerations over the next week and a half. I want to either get ahead of what I know the co-defendants are going to put forth in their responses to this. I want to get ahead of that. That way there's not only a one-sided argument on the table to be considered. I want there to be a counter for it. Because this judge, to me, just seems to love to look for those counter arguments. He loves to say, well, what about this? If this is the case, what about in something that's pre-conviction? We're not in the conviction phase yet. What about something that's pre-trial? I think you got to put that stuff forward because he's asking for it. And that strategy, my opinion, would be different if I had a different read of the judge or this was a different judge sitting there. But they are two strategies, and the state is probably more informed with their decision to not address it. But it's always risk versus reward. And then Erica says, I invested in this case. It's necessary and a very crucial case. I'm disappointed in her choices, though. It's just one of those things. You're like, oh my God, why does it have to be over? It's like that long running meme. It's like always, it's over a man. It's over a woman. Like a relationship can crumble so many cookies. And hey, Mr. Minutes, good morning. And then Chevette Valentine, hey, how are you? Actually, do you want to, if you want to email me, Chevette, so my name's Kat with 2 T's. Wagner is the last name. Kat@KattWagner.com. If you want to send me an email and you want to come up, we can do a stream on the Scottie Pippen suit. If you want to do that, send me an email. We can get you. I use StreamYard, so if you have it already, I just send you a link and we can coordinate a time. So Duddy K, respect cat haters be damned. And then Erica Dixon, I agree. Speculation is the theme of this entire discourse. And yeah, so Chicken Little, that's, and again, that came out in the Senate hearing. I don't think it's on the record, but that public brand PR is like, oh. Erica says the people charged wreaked havoc on Fulton County election employees and the residents. Mark Martin says part of the problem is Fulton County did keep a close eye on Fani's spending. Wade should have earned $175,000 a year, but never swore an oath of office, so he continued to have other cases. So Mark, one of the things that kind of I wanted to look at was when he was in Cobb County and was making $550 an hour with under Sonia Allen. I think that's a weird rabbit hole in and of itself. And I'm curious to know what he found when he was looking at like possible prison misconduct. I meant to go look for a report. So much happens though, and then I have like a full-time contracts I'm working on and my actual day job. But yeah, that was a rabbit hole I wanted to go down, and I forgot about it since yesterday. And then Fani complained under oath that she had to take a pay cut when she became DA. Yeah, so that's another thing. I was like, dang, she earns a lot less. She earns a lot less, and honestly, I would say she's you know, her qualifications, her experience, her position, the role. That was kind of shocking to me. And then you're in New Orleans. And then let's see, let's wrap that up. Guys, again, this is going to redirect to another streamer. He's an attorney. He is usually covering the YSL RICO case. He has a funny accent, so he's really smooth and funny to listen to. If you're interested in the YSL case, give him a subscribe when it redirects if you want to go over there. But right now he's looking at the Georgia Senate hearing from yesterday. If you missed it or want to revisit it, I've decided to try out that redirect feature. So that's all. I'm going to end this now, and we don't have that ethics hearing apparently, so we're not going to have that. If there's any new filings, I don't know if I will do a reading of them unless they're... We got one on the table here that addresses a lot. If the state replies to these replies, we'll do a live on that because I would love to see that and see if they start tackling these things. Rather than that, who knows? Maybe the next time we'll have a serious update is from McAfee. You guys all take care. I love having you guys in the chat. If you're new, hello. Feel free to chat and share your opinions. I'm always open to really any side of anything. I have different opinions on different cases when it comes to the same legal issues. And there are some cases that I don't care what the situation of the case is. The legal issue is like the top centerpiece of my thoughts. But I love a counter opinion. I love to be challenged and I love to learn new things. So if you're new, feel free to express yourself and your viewpoints at any time in this chat. You guys, thanks all for joining me. I love having a chat where you guys share your thoughts. And even though I'm not going to cover... I don't think we have any Fani Willis stuff coming up. I may have something new for you this Friday for Jonathan Major's case from looking back at the trial that I think will be really fun to look at. So stay tuned for a Friday night live stream with a new reading from the Jonathan Major's case. You guys have a good one and enjoy the rest of your day.